All right, let's begin that discussion. Joining me in studio are Kibe Mungai and Dunstan Omari, both advocates, to get their reactions to a tough-talking President Uhuru Kenyatta at State House while addressing Jubilee leaders. He said that he would deal with the judiciary if re-elected. Is that a threat? Before I get your reactions to that, let's listen into what the president had to say a bit early on today.
Tumeagree, umesema 60 days turudi kwa uchaguzi. Jubilee, we are ready. Na tunataka IBC watangaze siku. Na sasa kwa sababu tunasikia wenzetu ndio wamerudi kesi tena, sasa lazima tuwe na IBC mpya. Let me tell you.
All right, that was the wrong statement, but I'm sure you followed the proceedings from earlier in the day. Kibe, let me get your reactions. What do you make of the president's remarks towards the Supreme Court?
Well, the president is a politician. We expect politicians to speak like politicians, but we need to listen to what is the message, understand their disappointments. I believe the profound shock that the president and most of his supporters must have felt, the disappointment explains the rage that continues to persist even up to this time. I believe it's going to subside soon. But of course, what I hear the president to be saying, I don't really take it to be a threat, because what he said is that he will fix the judiciary. Of course, the word fix, as a constitutional lawyer, I would like to understand it, that there are options under the Constitution, and particularly to Jubilee government with a large majority, that an attempt is likely to be made, if he succeeds, to reform the judiciary. One of the methods are prescribed by the constitutions. Personally, I hope we don't get there, because I think I respect the current constitutional provisions as they stand. But the reason why we are here is also important. Strictly speaking, I did not see the judiciary in deciding questions, particularly concerning largely political matters to do with elections and what is called the political doctrine questions. Questions that are uniquely within the competence of the political organs of the state, should observe an element of caution.
But the thing is, you have some from the legal fraternity, the LSK, the Kenya Magistrates and Judges Association, saying this warranted a threat towards the Supreme Court.
I didn't get it to be a threat, because I think basically what they are saying, I don't expect the president to deliver it as a threat. He's saying that he's respecting it.
Okay.
But if he says he will fix it, the fixing of it would be the fixing with regard to the Constitution. And again, I say that personally, we must delink the questions of personnel and if they have done anything wrong.
Okay,
and my own view, before we go there, my own view is no judge can commit any wrong because of making a decision that you disagree with. Of course, you can say this decision is not right, like I have said. I don't believe this decision is right,
so Dunstan,
but that in itself does not entitle you.
Did you read the president's comments that way?
The person.
Did you read them that way?
Totally opposite. I saw the head of state attack the judiciary. The independence of the judiciary is totally under attack. And I'm calling upon every Kenyan of any goodwill and anybody who knows the history where the judiciary was when the security of tenure of judges was taken. And the Attorney General, then Matthew Mugai Muli, is the one who said, take it, we don't need it. Let us serve under the president's pleasure. So where we talk about the judiciary, every Kenyan should be very alert that the other arms of government have a tenure of 5 years. The legislature 5 years, the executive 5 years, the bureaucracy and the judiciary remain intact. So that is the last call where every Kenyan's hope lies on. I've seen the president. He's asking whether the people are really vifaranga. He's alluding to Article 1 of the sovereignty of the people. That sovereignty of the people is the sovereignty that created the Constitution. And that Constitution is in itself saying it has given the Supreme Court the last word.
Right.
Anybody aggrieved with the decision of the Supreme Court has nowhere to appeal. That was what we Kenyans said. So anybody trying to justify, and this is not an attack only from the president, NASA has equally attacked the judiciary in equal measure. Right. So it is the whole political class that Kenyans, we need to be alert that both NASA and Jubilee are attacking the independence of the judiciary.
And speaking of the political class's reactions to the Supreme Court ruling, let's listen into what the Deputy President had to say.
Na tunataka Maraga atusikie vizuri. Kwa sababu he has had his day. Ours is coming. And by the way, that is not a threat. He has had his day. He has done his game. Our day is coming.
So, Kibe, what do you think the Deputy President made by that? What do you mean by that? He said it's not a threat,
yes,
but we're waiting for our day.
Yeah, as I've said, and let us first of all establish first principle here. And the first principle, as far as I'm concerned, is that occasionally politicians from both sides have behaved badly to rulings. And when they disagree with it, they say that the judiciary is not independent, a lot of things is partisans, without looking at the merits of the case. Personally, I would want to say that from both sides of professionals and many ordinary people, good people of Kenya, many of them believe in an independent judiciary, which should be respected. But again, having said that, it is also important to remember this, that the different reactions to this is the fact that the decisions that was given yesterday, it is not the common decisions that you expect in election matters, because when you read even the brief ruling that was given, the question has always been, you have said there were irregularities. If there were irregularities, did they affect the outcome? But from the issues that from the word go, the Supreme Court appears to have decided that are going to decide the case, the game appears to have been rigged against the respondents, in the sense that instead of posing the question, did the alleged irregularities affect the elections, they answered, did they affect the integrity of the process? Now, integrity is a gray area. It is dicey. How much do we know that you're a person of integrity? Or what is my integrity? You get it? There is no easy formula to decide on that. But when you say how you affected the results, it is easy to say, I defeated you by a huge margin. So that even if we were to say that there are doubts about 500,000 votes, the other 900,000 would still have been enough for me to win. And having understood that, therefore, then you begin to understand why people would be feeling seriously let down that the judges appeared not to have followed the law as laid down throughout the entire Commonwealth and the common law world. If that happens, then if people now end up concluding that clearly this is an act of political decisions, political partisanship, on the face of it, they would be justified.
Well, it certainly is
and
a
I'm
very
not saying they are right,
unprecedented ruling, because
but they would be
it's the first time this
justified
has been done in Africa, Dunstan, and that's why a lot of people are wondering, how did this happen? How do we get to a point where the Supreme Court made what some would call a legal radical ruling?
I'll tell you, and Kenyans should look the Constitution. What was in court was a contest between the Kenyan Constitution and the common law interpretation and way of deciding cases. Kenya made their constitution in 2010. And in Article 256, I wish it could be put live to everybody, the Constitution by itself says how matters constitutional should be interpreted. One, it should be interpreted in a manner that develops the law. The common law doctrine was interpretation in a manner that maintains the status quo. So that is why everybody is saying, we knew very well. Jubilee was telling NASA, go to court. don't go on the streets because the interpretation, the common law interpretation, holds that Jubilee will win. But they never read this Article 256 that provides the parameter, the tool, the djembe on what to do when such a frame is put. Number two, when you look at Article 256, it is also saying that question must be interpreted in a purposeful manner that gets the spirit of the Constitution. Jubilee never saw anything called the spirit of the Constitution. So in my own view, the type of rage and the type of denial we are seeing is to me, understand it, because it was simply that the respondents did not respond to the petition as presented. Had they responded to the petition as presented, the 2013 decision was numbers. Raila Odinga was claiming he had the numbers. He could not prove the numbers. The 2017 petition was purely the processes. And you cannot be telling people, I have 10 million. The question is, show us from the source where the 10 million.
And
so
you bring something very important, which is the whole issue of the processes.
That is the question.
Which is now why the IEBC is under fire, because they don't have, at least from the NASA side, faith or confidence in the IEBC carrying out this repeat election. Let's listen in to Raila and Kalonzo yesterday on their sentiments on that. Okay, I understand we're having issues with that audio, but we also heard Ekuru Aukot saying, why not the UN carry out the management of these elections? How feasible is that? Because legally the IEBC is mandated to manage the elections here in Kenya, Kibe.
If you have a doctorate in law, like Ekuru Aukot, then you go there saying the UN should conduct the elections in Kenya, and Kenya is not a failed state. That's why you have to be the president of Kenya. I would want, first of all, he's a friend of mine, to ask him whether he was serious or he wasn't.
Hold that thought. I hear that bite is ready. Let's listen in to Ekuru Aukot.
Kenya will never be the same again. Like it has been said before, at Third Way Alliance, we are now going to pursue those people who committed irregularities, illegalities. They cannot hold another election again in this country. Chebukati and his ilk must be punished. We are therefore going to push for a neutral electoral management body. Our view has been, from the past as it is now, that perhaps the United Nations must hold the next general election. But it cannot be Chebukati and his people, because these are already criminals who must be charged in a proper court of law.
Okay, I can see both of you, learned friends, smiling and shaking your heads at that comment. I'll let you finish, Kibe, before we get to Dunstan.
Yeah, of course, I don't want to comment on that. I believe the day you call Ekuru Aukot here, he should feel very ashamed that he said that, because you have just come from the Supreme Court. They were speaking outside the court. The Supreme Court has made 2 orders. It has nullified an election, and it is actually important to note this. Give credit to Uhuru Kenyatta and his team, that to the extent that the Supreme Court said your election has been nullified, he has accepted it and he has gone out there to campaign. But to the extent that the same Supreme Court ordered IEBC to conduct an elections within 60 days, NASA is defying that. People don't want to look at that. There is the same judgment where it affects NASA. NASA says we want the electoral body to be changed. This would go against the order of the Supreme Court. But more importantly for me is that if you just try to imagine what is the end game in all this, you see a scenario whereby the Supreme Court is going to have an egg on their faces. The judges who decide in the majority. Because you can imagine you have given somebody a judgment, giving him a second chance to go and win a presidential elections. But the first thing that he does is actually to make it almost impossible for your orders to be implemented. What is the scenario here? The scenario here is this, that if NASA does not see the light and they change that course, then you are going to see a very serious constitutional crisis in Kenya, where everybody is going now to look at the Supreme Court and say, oh, there goes your friends. We are right down into a crisis. We just have 60 days. These shenanigans that you are going to change all these kind of things, this is not possible. So I wonder how these judges are feeling when they see the beneficiary of your orders is actually a person who believes in
So not enough time is your argument as to why we can't do this. And we heard President Uhuru Kenyatta, the deputy president, saying that NASA had accepted the results of the other elective seats in the election that was managed by the same IEBC they want thrown out. So does this now invalidate the other seats that were contested?
Of course not.
Before I get your comment on that, let's listen into the DP.
Wao ndio walienda kufanya maandamano, wakafukuza IEBC ambayo ilikuweko. Sisi tukawa wangwana, wakaleta IEBC hii. Sisi tunataka kuwaambia my friends, hawawezi kutuzungusha tena. IEBC hii ndio itasimamia uchaguzi inayokuja. This is the IEBC. Wao wenyewe hawawezi tena kutufanyia maandamano watubadilishe. Hapana. Na mimi nataka niseme hivi. Hii IEBC niulize watu wa NASA. The same IEBC that is going to preside over the repeat of the presidential election is the same IEBC that presided over the election of their governors, of their senators, of their members of parliament, of their women reps, of their MCAs. If they have a problem with this IEBC, then they should ask all their officials elected by this IEBC or their elections to resign so that we can know they are serious.
Okay, and Dunstan, this now kind of opens up a can of worms in terms of other petitions now coming out if they feel that the IEBC was not credible in the other posts that were contested.
First, let me advise my learned Daktari that he is the framer, he is the architect of that constitution. And the constitution only knows one entity called the IEBC, not the UN, not any other body. So it is the IEBC that provides for, and it is within the constitution. It is not as it is being put that the Supreme Court said the IEBC to conduct elections. The constitution provides by itself, upon annulling an election, then the other election must be conducted with an entity created by the constitution called the IEBC. So that one is not a subject of discussion. Number two, you've asked the question, what are the consequences of the decision that we have? In the Mutunga decision, Raila 1 of 2013, the jurisprudence that came out of that court is that you can never nullify a presidential election. In light with the Commonwealth traditions, in light with every type of tradition of in the 2017, the sitting court was not supposed to be bound by that judgment because they are of the same jurisdiction. Both the Mutunga court and the Maraga court that was sitting are equal. So anybody can run away from that. What I'm seeing from that judgment is that the new law has completely moved away from what was in 2013. All the petitions that were filed under the 2013 elections, almost all of them collapsed, unless those ones that succeeded were counting of the ballots. What is likely to be, and the type of agitation you are seeing, is that almost all these people claiming or have been sworn in as governors, as members of parliament, as MCA, we as lawyers, we are waiting for that decision. We will use it to file petitions. Almost 95% will lose their seats.
Okay.
But the seats will be lost not because of a generalized theory. Each case, each petition will be filed, the evidence will be looked at, and therefore, if the court will find that there were irregularities as defined by this decision, that election will be nullified.
Before we wrap up, I want to get both of your takes on this. After Chief Justice Maraga had made his ruling, they said he was very courageous to make a ruling against a man who appointed him to the Supreme Court. Do you feel the ruling now has restored faith in the independence of the judiciary? I'll start with you, Kibe.
I think it is hard to say that the ruling was going to put faith in the independence of the judiciary, except in a very narrow, restricted sense, but which is also very partisan. Because, truth of God, look at IEBC, for example. Any IEBC that does not return a Raila Odinga victory will never be a good IEBC. And therefore, we Kenyans probably need to face it up, that, and we need not be moral cowards anymore, that if every time that somebody begins rallies and agitation, you must yield to whatever things they want. This also includes the religious leaders. I think it is both bad manners and is setting the bad precedent. The same thing, if the courts are only going to be assumed to be independent because they have made a decision that NASA agrees with, that is going to be phony independence. I think for me, the key issue about the independence of the judiciary, even in this matter, and they were egged on even by Jubilee to go to court. So if you let somebody goes to court, you expect our decisions to be in your favor or against you. But the key issue for the judiciary as far as independence goes is this, that on the issues that are there, the law, evidence, and the facts, there must be true fidelity to that. Reading the small comments made by Justice Njoki Dongo and Justice Ojwang, they seem to be raising critical issues about the facts and the evidence as you are characterizing them does not seem to be the truth, which raises a big question of integrity, which is actually something that you share. So that even the old jurisprudence that has been known, if you suddenly change it in the biggest of cases, and as it were, the famous Justice Madan, many of us lawyers respect him, if he says that a judicial decision should not shock the people, a judicial decision should be understandable to the people. Now, the people cannot be able to understand that suddenly in Kenya, you can win an election by such a big margin, and it is possible, where you never saw violence, you never saw bribery, and it is suddenly possible. That is going to be overturned.
Let's get
that is what is going, in my view, to destroy independence of the judiciary in this country.
Go ahead, Answer.
It is so simple. The IBC was given a lifeline. Open the server, produce the basis of this number. What was the explanation? A man is asleep. The servers are elsewhere. They were given proper time and opportunity to put themselves in compliance with what the Constitution says, the right to information. Number two, the independence of the judiciary and independence of every organ is subject to the judiciary's scrutiny. They failed that test. The problem that we have now is an entity that failed to clean itself and now wants every Kenyan to run with it. The question of Article 10, the question of transparency, accountability, and accountable to the citizens of this nation, because we are the sovereign. Nobody is the sovereign. That is the question that we have today. Lastly, when I look at my good senior's argument that the judges have an issue of integrity, Article 168 of the Constitution, which Kenyans have seen on Nation TV just now, provides for the mechanisms to remove a judge who anybody believes has failed the test of integrity. It is not in rallies. Unlike other positions where you can rally and call people to mass action, the Constitution provides for ways of removing those people. And that is what I've also told the NASA people, that the IBC commissioners, the removal of commissioners is provided by the Constitution. This country cannot be run as a banana country, where because you are aggrieved, then you say this. In 2013, the opposite is what we have. That time, a certain position, a certain constituency felt totally aggrieved, and a certain constituency felt totally celebrating. The reverse has happened. What has changed? It is the same court.
We need to
that when you move into court, you either get it or lose it.
Okay, thank you so much, Danstan Omari, Kibe Mungai, for your insights. I'm seeing Ekuro Court has actually responded to you, Kibe,
yes,
on Twitter. He says, tell Mungai that political matters require political solutions, not armchair analysts. IBC must be punished. I'm sure that's a matter you'll handle in your own time with him, because we do not have time.
I only, just in a second.
30 seconds.
Let him respond.
Yeah, the thing is this. If you say something about, you are speaking as a lawyer who has a doctorate, that's why you wanted to be taken seriously. If suddenly you cannot be taken seriously, then you have to live up with it, not to call other people armchair analysts. I've spoken in substance, address the substance of what I'm saying.
Okay.
That is what is called
and I'm sure he'll have the right of reply in 140 characters or less on Twitter. Thank you so much, gentlemen, for joining me.